Blair.
Well, hi everyone. It's a great pleasure to be here today, just as the world leaders gather to discuss international peace and security, the rule of law, and the protection of human rights. Or at least that's what I hope they're discussing. And of course, I'm delighted to be here as part of Concordia, and particularly that as its good governance and democracy pipeline, which is focusing on the rule of law, international justice, good governance, and accountable governments. Because these are the ingredients that are essential for the protection of human rights and the protection of trade, business, and investment. And at its best, the complex architecture of international trade offers foreign investors protection from capricious governments, and at the same time recognizes the rights that states have to develop and adapt their local laws to reflect the changing priorities of the different governments and the human rights of its citizens. However, these structures are finely balanced, and they are subject to occasional disturbance, sometimes by states and sometimes by investors. And today I wanted to focus on the vulnerability of investors. Imagine a stranger in a foreign country, and suddenly the government turns against you, where malign state interference unreasonably undermines your investments and threatens you, your people, your business, and your reputation. Now, of course, foreign investment laws and the tribunals that enforce them provide a layer of international protection against political vagaries and the volatility of host states. And in extreme cases, if assets are expropriated or the regulatory framework changed in a country to render an investment worthless, international tribunals can provide a monetary remedy. And guys, I'm talking about big bucks. Just last year, Nigeria was presented with a bill for $9 billion. That's 20% of its foreign reserves, after losing a long-running arbitration battle over an aborted gas project. And more recently, Pakistan was ordered to pay nearly $6 billion for blocking a mining project, which all happened nearly a decade ago. But you know, intimidatory state action is not limited to property. It can be and is directed at investors or the investor's employees in person. So what if a state chooses to use its criminal laws not to punish genuine crimes, but to intimidate an investor or on behalf of those able to exert influence to further their own political and commercial ends? In country, investors and their staff can face vexatious prosecution and arbitrary detention. And you know, once you're caught up in the criminal justice system, a stranger can be particularly vulnerable, stigmatized, held in poor conditions, faced with proceedings in an unknown language, and sometimes unable to contact loved ones or access legal advice. And even if investors are not in the country, they are vulnerable to states using their extraterritorial powers by issuing international arrest warrants or Interpol notices to apply to try and compel investors to do what the country wants them to do. At the very least, it can make it very difficult for an investor to travel and conduct business around the world. I've seen clients stopped at borders and detained because a hostile state has issued an arrest warrant against it and then registered it with Interpol. Or in Europe, the European arrest warrant is enforceable in every European member state without question. But you know, investors are not entirely helpless. International human rights law is universal and can be used to protect investors when a state unfairly weaponizes its institutions. For instance, those treaty arbitration tribunals I mentioned can order a state to stop, as well as imposing monetary compensation, by using the fair and equitable treatment guarantees which are found in most investment treaties. And we are now seeing investors successfully using this well-worn treaty provision to protect not just the capital invested, but also the human rights of the investors themselves. If a treatment of an investor sounds a lot like something that a human rights court has previously judged to be a violation, then a tribunal is unlikely to find that it's defensible, but more that it is unfair and inequitable treatment. But you know, it's not just using the investment tribunals. Other international human rights mechanisms can also help unfairly persecuted investors. And I wanted to give you the example of Marsha Lavareva, who is my client, as I'm her international human rights counsel. Marsha is a leading Russian businesswoman, but she has strong ties here in America. She was educated at the Wharton School at the University of Pennsylvania, and her son, Ivan, has US citizenship, and he will be 5 next week. Marsha was unfairly convicted in Kuwait just last year on unsubstantiated charges of embezzlement, and she was sentenced to 10 years hard labor. But while she battles to clear her name, she is stuck in Kuwait, banned from leaving there, even to be with her mother, who is having serious medical treatment here in the United States and who is herself a US citizen. Do you know, I was in Kuwait just last week to attend the latest hearing, and I have to tell you that once again, the court procrastinated, leaving Marsha stuck in this terrible limbo. The case is one of the most worrying that I have come across. There she is, a white-collar executive with an Ivy League education, and frankly, until recently, a very good lifestyle. But what could happen to her could happen to anyone when the rule of law is subverted. Now, you may have read about Marsha because she has quite an extraordinary cast list of backers, including Neil Bush, son of the late president and brother, of course, to George W., Louis Freeth, the former FBI director, Tatiana Yumasheva, the youngest daughter of the late President Boris Yeltsin, and, for a bit of glamour, Hollywood's Amber Heard, who I'm sure you have all heard of. Trust me when I say Marshas Story has so many twists and turns, so many scoundrels and villains, that frankly, Netflix and Amazon should be mad not to take an option. Imagine being accused of a crime which not only did you not commit, but for which there is actually no reliable evidence that any crime even happened. Imagine the star prosecution witness was actually convicted of forging the very documents relied on by the prosecution in Marsha's case to convict her. And then, when at one time the stress of the hearing got to her and she wanted to be sick at the back of the court, the judge said to her, you just had to be sick in the back of the court, and had no desire to even adjourn the proceedings. There was a travesty of a trial, and she was convicted without even being allowed to advance a defense. And then she found herself detained in a jail cell in Kuwait, designed for 2 women, but actually it was occupied by 6 other women, none of whom spoke her language. Marsha was living in this nightmare and still is. She spent 474 days in that cell until finally we managed to get her released on bail and her conviction quashed. But she's still there because there's going to be a rehearing of the case. And while she's on bail, she is constantly followed. I myself was followed when I visited her. Her Kuwaiti defense counsel is actually being prosecuted. And now her international advisors, predominantly Americans, but me included, are in the crosshairs with absurd threats and allegations that we are committing treason or assisting treason simply by defending her. And then there's the judge, who first of all recused himself from hearing her case because he said, I couldn't fairly try it, only then to be forced to do a U-turn and unrecuse himself, and now is hearing the case. And concerns about his independence were borne out despite the fact that she'd already paid bail of $33 million. After the conviction was set aside, this judge then set an additional bail mounting to a total of $65 million. That's not bail, that's absolute persecution. Of course, Marsha did not have $65 million just around to pay. And it took us nearly a month before we managed to get that bail overturned to a more manageable figure and finally get her out of that prison cell and back with her son where she goes, where she belongs. But the list goes on and on. I mean, honestly, it makes the Game of Thrones look tame. I was approached to act when Marsha was in prison. The injustice of her case was obvious, but it was clear that the efforts we were making inside Kuwait were proving fruitless. So I decided we needed to internationalize the issue. And our first step was to file an urgent appeal to the UN Working Group on Arbitrary Detention. Not something necessarily that many of you will have come across, but it comes out of the International Covenant on Political and Civil Rights, which Kuwait is a signatory of. And it provides that Marsha is entitled to a fair trial. And if the Kuwaiti judicial system does not provide, and it didn't, then the state of Kuwait is itself held accountable. The rule of law depends on an independent and impartial judiciary, as well as the ability for defense counsel to vigorously defend their clients without improper interference or reprisals by the state. Sadly, these principles were not observed in Marsha's case. And so we went to another UN mechanism, this time the UN Special Rapporteur on the independence of judges and lawyers. Now, the use of the UN appeals, obviously they don't send troops in, but it does encourage the state in question to focus on the case and onto due process, because they don't want the international community, including investors, to think that they're not safe. Because it's not good business to unjustly imprison foreign investors and to have the matter talked about at the UN. And it could have just been coincidence, but after more than a year of futile domestic appeals, within weeks of our UN complaints, Marsha's conviction was overturned, and, as I said, she was finally released on bail. Not free, because she's awaiting a retrial, but still out. But you know, the fight for Marsha's fair trial rights and her liberty continues. But you know, even if you're not in country, an investor can be vulnerable to a hostile state. Misusing international arrest warrants or an Interpol notice can put you seriously at risk of being arrested at border crossings or being banned from traveling. And look at how some notorious countries have used or misused the Interpol system to pursue opponents. A red notice or a diffusion from Interpol lets one country signal to all other Interpol members, which, by the way, is every country in the world except North Korea, that it wants a person arrested with a view to extradition. It isn't itself an arrest warrant, and police forces don't have to obey it, but if the requesting country chooses to publish it on the public database, then a person can be detained at borders, can be cut off from their bank accounts, and in theory, lose access to the entire global financial system. Fortunately, Interpol has become aware that this system has been open to misuse. And in recent years, it's changed its processes, allowing for challenges to notices on grounds of human rights concerns. So it is now possible to challenge red notices where the process resulting in the notice has violated the Universal Declaration of Human Rights. This means that where we as lawyers can show that international human rights law has been violated, we can have that notice removed. So seeking redress for abuses of international human rights law is no longer just something confined to interstate relations. Cases like that of Marsha raise the fundamental concerns about the treatment of foreign business executives. But they also show that they are not powerless, that international human rights law is a useful tool to protect against unjust government action and to uphold the rule of law. You know, just recently, when I was speaking about Marsha's case, I was challenged by a journalist who said, well, surely these UN bodies are not for use by rich people. But the reality is that when faced by an overwhelming coercive power of the state, unjustly criminalized for legitimate business conduct, stripped of fundamental freedoms and imprisoned, any individual would feel vulnerable, violated, and in desperate need of help. We are all here at Concordia's annual summit because we care about identifying challenges and working together to uphold rights for all and to create solutions for greater social impact. So I hope that these remarks start a conversation about the dangers of the criminalization of legitimate business conduct, about how it undermines the rule of law, individual rights, and the system of international investment on which our societies rely, and what we can do to help. I look forward to continuing this discussion with you over the next few days. Thank you.